I'd like to talk very generally about defenses that are offered in the federal court system and your general background and experience in offering those defenses and what your experience is with them. So let's start with the defense of entrapment. Can you describe generally what that defense is and how it's commonly utilized in federal practice?
Entrapment is, in the vernacular, I was set up. I wasn't going to commit a crime. I was minding my own business, and the government got involved, and they put in front of me an offer that was too good to refuse, and I broke the law. That's what a layperson understands entrapment to be, and that's to a large degree what entrapment is. The difference between state court entrapment and federal court entrapment as a defense applies is night and day. In the state court, a defendant has to prove that he was entrapped. His predisposition to commit a crime and the government's relationship to him, what did they do to induce him to commit the crime, is not as relevant as it is in federal court. In federal court, a defendant has to present evidence of entrapment, that I was not predisposed to commit this crime, that the government induced me to do so by making me an offer that I couldn't refuse, by playing on my sympathies, on my needs, by presenting me an opportunity that I couldn't otherwise, given who I was, take advantage of, and caused me to break the law. Once a defendant has raised that issue in front of a jury, then the government in federal court has to disprove that the defendant was entrapped. And because of the different type of defense of entrapment in federal court as to state court, you have to know how it applies. With federal sentencing the way that it is now, with the proliferation of joint state and federal task forces who are looking to set up reverse stings, these fake stash house robbery type cases, some of it involving health care, bank fraud, it's critical that the entrapment defense be presented properly and that it be presented in a way that a jury can either determine that the government manipulated the case in order to get an extraordinary sentence, or they created some form of unique type of inducement that caused an otherwise innocent person to break the law. These defenses are very important in federal court, and the law is changing as we speak. And because of my experience, particularly given the Pullman case, where the Ninth Circuit reversed Mr. Pullman's conviction, ordered him immediately released, and set forth the legal standard for entrapment in this circuit, I have spent a lot of time preparing these defenses and have had great success with them.